Today, we're going to present on the topic of copyright originality as a requirement for protection. Let's get started.
Copyright are also known as the author's right, which is a legal term used to describe the rights which the creator has over their literary and artistic works. It is acquiring of a title of ownership on specified products or anything which being conferred as a legal right created by the law of a country. In the aspect of the originality of such creation, whether it is really original and authentic and not conveys of any ambiguity. Originality of a creation must be measured by the effort made by the creator and hardly to be differentiated with any other products which might have infringed the original one.
Basic requirements of originality of copyright. The first one is independent creation. Copyright need not to be new as long as the creation of work is not copied from other sources. In the case of Kiwi Brands against Multiview Enterprises, the judge said that a person may produce a similar work as the other person, but each is entitled to copyright of the representation of the work. The second one is minimum amount of creativity. It closely related to the sufficient effort. However, if only there is an effort without a spark of creativity, it sometimes cannot be considered as originality. In the first publication against Rural Telephone Service Company, the telephone directory cannot be a copyright work as it does not have a minimum level of creativity.
Copyright in United States. Suite of the Pro, an intellectual properties law doctrine that related to copyright law. Minimum degree of creativity is an effort of the author that possesses at least degree of creativity. It needs to be independent creation and a modicum of creativity. It needs to provide at least some minimum degree of creativity and minimum creative spark. The first publication against Rural Telephone Service case. Rural Telephone Service is the certified public utility that provides telephone service in Northwest Kansas. It has two types of telephone books, which are white pages for business and the yellow pages. The another company is the Fish, get called by the rural because Fish Company copied most of the information in the white pages and compiled it under the Fish Company. However, rural lost to the Fish when the court held that the data information that can be categorized as fact cannot be copyrighted. Fact cannot be proved as originality in copyright law. Rural failed to prove the minimum degree of creativity in its white pages. This cause based on not infringement the rural's copyrights because of rural's copyright is invalid.
Copyright originality test in United Kingdom under suite of the Bro under the Copyright Design and Patent Act 1988 for copyright to exist in a work, the work must be original. However, court does not have stated the literal meaning for this. The illustration is that if person A makes a work in which copyright exists and person B subsequently adds his skill, judgment and labor, person B altering the form of A's work and will be potentially have a copyright in the work he produced. Cases University of London Press against University Tutorial Press. The court held that the Copyright Act does not need that express be in original or novel form. It must originate from the author. The plaintiff should not be denied copyright as original within the meaning of copyright. Minimum level of creativity. United States law higher use this doctrine rather than United Kingdom itself. In United States, the general minimum threshold for protection is higher, as English law applied more on the doctrine suite of Pro to test the originality of the works. The difference between the traditional approach to originality in the UK and the US is a quantitative one, where the subject matter of protection in both jurisdictions is the author property which he made. If you look at UK copyright law, realize that the minimum threshold of originality seems to depend on the type of work. Clear distinction between quantitative and qualitative labor that has to go into the work to turn it original.
On domestic level, the case that going to be observed is between Durham Mines and Denver Heights versus Elster Material Limited and Honor in 2015. The fact of the case are imagined dispute between parties regarding a drawing for a type of water meter known as CAN PSM water meter and its predecessor. These cases are going to get through under the Section 42 of the Copyright Act 1987. In this case, the court will find two important positions being taken in respect of both statutory law, which is the test of true copy, and the common law regarding the existence of the copyright in revised manner or modified work in the copyright realm. In international level, the case that going to be observed is between the Bureau Kills Lithographic Company versus Saroni in 1884. The case has been reviewed under the United States Code Title 17, Chapter 1, Section 102A, which is stated that the protection will be given upon the original work. The work itself must be original to qualify for a copyright protection. On the question of definition of the originality should be chosen have been observed. In concise, it was important to give the protection to the copyright of a person's work. That's all from us. Thank you.